A copyright immediately jumps into being as soon as you create a new work of anything. So if I write a story, it's copyrighted the moment I write it. You can register the copyright with the Copyright Office for some fee, which basically allows you to recover statutory damages. It means you don't have to show loss. You can just say, I have this work, original work that's mine. I'm copyrighted it. If somebody copies it, then they owe me some fixed royalty for every instant of copying. That said, so if I write, I have some software, I write code out. If somebody looks at what my software does and says, that's pretty cool, I'm going to give it to my coders and say, here, don't look at the code, just write up something that does this. Their code is not infringing the copyright. The code is actually on the specific.
They have to rip it off kind of line by line.
Yeah, it has to. In order to show copyright infringement, you actually have to show that it's a copy, or it's either a copy, or you can. There's some issues where you say, well, it's a very close derivation. I took that and I maybe added a little bit to it, but by and large, you're looking at a copying issue. So there is an option. So you can certainly file. There's plenty of software patents that get filed. They have become harder to get. There was a whole area of patent law that for the last 15 or so years, probably longer than that, sort of business process patents. So it's taking, a lot of them boiled down to, well, here's some sort of economic something or other that we've now automated. I have code that basically, I take instead of having a pad of sales orders and writing them out, I go online and I do it. There are lots of patents that cover that kind of stuff, a new portal for taking that data and putting it in and making an automated sales order process. Those patents have become harder to get, and the ones that were issued in the last 10 or 15 years, many of them are probably invalid. There was a Supreme Court decision just about 2 years ago, 2014, June of 2014, called Alice versus CLS Bank. The Supreme Court, and honestly, the claims at issue in Alice versus CLS Bank were not terribly well written. As with most patent law court decisions come down to, gosh, that's a terrible patent. I mean, those are the things that are very vague and very hard. There's a lot of money involved. They're the ones that get fought all the way up to the Supreme Court. And the Supreme Court they're not patent lawyers. They're smart people. This particular one, basically the decision was these claims in the patent issue were too abstract. They effectively just sort of claimed an idea without having something significantly more involved with the idea. I forget, there was another one called Bilski, but they basically one of them had to do with escrow payments, effectively automating the escrow process. And it was a high-speed trading escrow process, right? So it was like, take the stuff, hold it here, and the other one was, I forget what it was off the top of my head. But again, sort of what was considered to be a fundamental economic practice that was just being automated. So that decision happened in 2014. The lower courts, the Court of Appeals for the Federal Circuit, which is the federal appeals court for all patent decisions, has heard something like a dozen cases since then that involve this same sort of question. And of those dozen or so cases, there's been one case that they've held that the patent was valid. So that trickles back down. The lower courts software patents are in doubt. And some people will say, software is not patentable anymore. The Alice decision was not a terribly lengthy decision. Justice Thomas is a fairly economical writer. He wrote the decision. Even then, it was still a 10, 15-page decision. If he'd wanted to say, if the court had agreed that software was not patentable, he could have been really economical. It would have been, this is an invalid patent because it patents software and software is not patentable. So some software is patentable, and I have clients that, in the database space, and if you can show that your claims are tied to some technical underpinning, it's not just automating some. If you read the claim and you say, this sounds like I could do it, albeit a lot slower. I could do it with pen and paper or by thinking about it. Even if it would say, I could do pen and paper, I could use 10 million legal pads in 20 years, but I could still get to the answer. Chances are your patent is probably not valid. But then there's a lot of stuff in the computer implemented invention space. A lot of database technologies, certainly a lot of networking. If you have hooks that requires that it be on a mobile device, if there's a user interface, those kind of things tend, under U.S. law currently, tend to be they tend to get you over that first hump. So what Alice did was add a more substantial first hurdle before you got to sort of arguing about the prior art. It was, is this something that should be eligible for patenting?
Okay.
And in the past, that had been, well, is it useful? Okay. There was not that first hurdle was not there.
Okay.
So now that is a substantive question. Is it something that's eligible for patenting in the first place?
So the first hurdle is basically you're not just automating something that's already done a particular way.
Yeah. That said, the law is very much in flux. The Patent Office has issued, I think now, 4. They just last week will actually be issuing another alert for clients here in the next couple of days. But they keep trying to tell their examiners how to examine patents.
Yeah.
Because frankly, the test is a mess. There's really no bright line rule. It's this is directed to an abstract idea. Okay, so like here's a further analysis, which is not really smart. I mean, the judges are really smart.
Yeah.
A lot of really smart lawyers. I think you got 100 of those people in a room and said, here's a patent. Is it eligible or not? You'd get, depending on the patent, you might get 60-40, 50-50.
Wow.
And it's very fact dependent. It's very examiner dependent when you're dealing with the patent office.
Okay, interesting.
And I've seen analysis that says, 2 patents that sound very much, technologically they're very similar, but they just got classified into different groups.
Yeah.
Maybe one sounded a little bit more economic practices like, and it got sent to this group that examines that kind of stuff, versus another one that maybe got sent over to the database group.
Yeah.
The economic practices group tends to be very unfriendly toward, everything gets an Alice-based rejection. And very similar sounding claims that went over here to the database guys, who just sort of assume that it's, of course, you have to have a computer involved. How are you doing this? Those tend to go right through.
Okay.
No problem. So there's going to be a lot more to come. It's certainly not settled. But that said, we get things allowed all the time that are, you could characterize as entirely software. But it's just a matter of making sure that it's very clear that you're on the specific details of, what problem you're solving, what technological. I saw a court case that basically characterized it as things that are sort of inventions that you could characterize as entrepreneurial in nature. Sort of, hey, this would be cool if we did this kind of business model, versus something that's technological in nature. Those first group are going to be harder to patent than the ones that you can clearly say, this is, there's computers talking to each other and they're integral to the whole process, and it required some clever something or other in the architecture or whatever else to make it work.